Hey, everybody, this is Chris Addig, and I want to talk to you today about the case of Anania v. McDonough. It's a case that just came out of the federal circuit, a new precedential opinion that came out on June 10th, 2021. As we jump into this case, I'm going to shorten up the case's procedural history a little bit. As with most appeals in the legacy appeals system, this particular case bounced to and from the Veterans Court like a paddleball. It went back and forth between the board and the court at least three times before we got to the Veterans Court memorandum decision that was ultimately appealed to the federal circuit. So let's talk a little bit about the facts of the Anania case. Mr. Anania is a veteran. He's got a claim in the legacy appeals system. He had until March 3rd of 2010 to file a substantive appeal in response to a VA supplemental statement of case. Now, remember, under the legacy appeals system, which we are no longer operating under, we're operating under the Appeals Modernization Act since February of 2019. But under the legacy appeals system, getting to the BVA required that the veteran first file a NOD, a notice of disagreement, then wait for a few years before the VA issued a statement of the case or a SOC or an SOC, and then the veteran had another 60 days to file a VA Form 9, which was also known as the substantive appeal. These documents comprised the appeal to the Board of Veterans Appeals. And it was a perfected appeal that was then certified to the BVA and docketed for a hearing or decision. The whole process took years, sometimes 3, 5, 8, 10 years. Well, in this particular case, Mr. Anania had until March 3rd of 2010 to file his substantive appeal to the BVA. In June 2012, his attorney sent a letter to the Board of Veterans Appeals requesting confirmation that it had docketed his substantive appeal. Shortly thereafter, the VA issued a supplemental statement of case finding that the VA Form 9 had not been timely filed, and in appealing that to the BVA, the veteran's lawyer prepared a sworn declaration explaining how he properly addressed, stamped, and placed for delivery in the mail the VA Form 9. So, what did the BVA and the Veterans Court say about this fact pattern, also known as the common law mailbox rule? The board denied the appeal, saying that the veteran had not overcome the presumption of regularity. Now, that's a legal theory that says that things are presumed to have happened in the regular way, absent evidence to the contrary. Now, I'm oversimplifying the presumption of regularity greatly just to get through this video. But the board held that an affidavit from a veteran's attorney was so self serving that it couldn't overcome the presumption of regularity. The Veterans Court, specifically Judge Sholin, who retired and took senior status in 2019, held that a party's own self serving testimony was per se inefficient or insufficient to establish the presumption of receipt under the common law mailbox rule. Now, per se is Latin for in and of itself, right? So it's insufficient in and of itself. There has to be something else, is what the Veterans Court was saying, in order to establish the presumption that the VA received something that had been properly placed in the mail. Mr. Anania appealed that decision to the Federal Circuit, which ultimately reversed the Veterans Court. And the Federal Circuit started with an explanation of what the common law mailbox rule was. So, what is the common law mailbox rule? This rule derives to at least the early 1800s, and it was well accepted in American law by the 1890s, and stated that if a letter properly directed is proved to have been either put into the post office or delivered to the postman, it is presumed from the known course of business in the post office department that it reached its destination at the regular time and was received by the person to whom it was addressed. In layman's terms, if you put something in the mail properly, it's presumed to have gotten there. Now, the rule is not conclusive. It's just a factual inference, and like most presumptions, it can be rebutted. But the burden to rebut the presumption of receipt under the common law mailbox rule is on the VA, because in terms of that common law mailbox rule, the presumption is that a properly addressed, stamped, and mailed item reached its destination within the VA. So, how did the Federal Circuit decide Mr. Anania's appeal? The Federal Circuit looked to case law within its own circuit. About 15 years earlier, the court had told the Veterans Court that it was wrong to say that extrinsic evidence, evidence outside the case, could not be used to show that a particular filing was timely. It told the Veterans Court that a veteran could invoke the common law mailbox rule only through direct proof of mailing or evidence of mailing customs or routine practice. The Federal Circuit then surveyed case law in several other federal circuits, the Second, Third, Fifth, Sixth, and Ninth Circuits. There's 10, I think there's 11 plus the Federal Circuit overall, and I'll have to double check that. It's been a while since I've counted them all, and I apologize if I got that wrong. But the circuits that the Federal Circuit surveyed, the Second, Third, Fifth, Sixth, and Ninth, all held in some way, or at least looked at these as the elements of this issue, whether a sworn statement can be credible evidence of mailing for the purposes of invoking the mailbox rule. And that's what the Federal Circuit ultimately held in this case. A sworn declaration or affidavit from a veteran or their attorney with sufficient specificity can be sufficient to invoke the common law mailbox rule's presumption that the VA received what the veteran mailed to it. Now, the Federal Circuit left open two paths for the VA to rebut the common law mailbox rule's presumption of receipt. First, if the sworn declaration or affidavit provided by the veteran or their representative is conclusory, it may not be sufficient to invoke the presumption of receipt in the first place. And we're going to talk about what that means in just a minute. Second, if the VA can sustain a credibility challenge to the affidavit or the sworn declaration, that may be enough to overcome the presumption. And there are really only three ways in the law to impeach someone's credibility, at least in terms of VA claims: perception, bias, or integrity. As to perception, somebody may not have personally perceived the facts at issue. As to bias, they might have a bias towards one side or another that's sufficient to question the validity of their observations or conclusions. And third, they might look at their integrity. Facts that lack integrity are not consistent with other facts in the record. We're not talking about integrity in terms of personal honor, but in terms of structural integrity between and among facts in a particular record in a case or appeal. So, what does Anania, the holding of Anania, mean for your VA claims and appeals? Well, let's start with this. The VA's inability to manage its mail, both incoming and outgoing, is notorious. So, best practices in dealing with delivery of documents to the VA is critical. First, if you can find a way to get electronic proof of delivery, that's ideal. Maybe it's a fax transmission receipt, a digital stamp from a direct upload to the VA's VBMS system, an email, or postal service tracking features, things along those lines. But second, short of that, certified mail, return receipt requested, and mail logs can be the best and most persuasive ways to show that something was properly mailed to the VA and may be presumed to have been received by the VA. But third, if you don't have those things, using a sworn declaration or an affidavit can be sufficiently used to sufficiently establish receipt, so long as it covers these points. First, you have to explain how you properly address the envelope. You wrote the address on there, and this is the address that you wrote on the front of the envelope, and put the address in there. Second, you have to show how you prepared it for mailing. You placed a stamp on the envelope. You used prepaid postage. You send it up in smoke signals, whatever the case may be. Obviously, smoke signals are not going to work. That's just me being facetious. But the point is, be specific in how you prepared that document for mailing. And then third, explain when and how you placed it into the mail system. From where you mailed it at the post office, maybe you placed it into one of those big blue postal service receptacles. Maybe you put it in front of the mailbox in front of your house and popped that flag up. Whatever you did, explain that to the VA in the sworn declaration. You don't need to go overboard with specificity. You don't need to say, first I walked out the front door, then I said hi to my neighbor, then I stopped to weed the flower bed, then I put the letter in the mailbox. You get the idea. Don't go overboard. What we're looking for here are just enough facts to show that the statement that you mailed the letter to the VA properly is not a conclusory statement. Now, if you don't want to spend the extra $8 to $10 on certified mail, and I don't blame you, as much as we mail stuff to the VA, that can get to be an incredible burden, particularly for veterans who may not have a lot of cash available for that sort of foolishness in the first place, to have to prove everything that they've mailed to the VA by paying $8 to $10 a pop. Whenever you send something to the VA, though, you can prepare an affidavit like the one I just described and keep it in your important VA papers folder. If you do this every time you mail something to the VA, you can effectively create a mail log. And the more contemporaneous your sworn declaration is to the mailing at issue, the more difficulty the VA will have in overcoming the common law mailbox rules presumption of receipt. So, one final word of caution. If you did not mail something to the VA, don't try to use this method to show that you did. First, experienced attorneys are cynics, and cynics work hard to disprove things because we don't want to be wrong. We don't want to rely on something that's incorrect or unprovable. And so, board attorneys, board judges, court clerks, court attorneys, court judges, clerks in the federal circuit judges, all of these folks, we are trained to be cynics. And if there's a problem in terms of you not actually mailing something to the VA and then using this method to try to cover that up, those folks are going to find that integrity issue in the record, I promise you. Second, to do so, to provide one of these affidavits when you didn't actually mail something to the VA is to commit fraud against the US government. And among many, many other penalties that nobody ever wants to have to deal with, it could lead to severance of any service connection benefits that resulted from that fraud. But if you did place a document in the mail and if you did properly address it and put a stamp on it, you are entitled by law to rely on the presumption that the VA received what you properly mailed. In that case, use the common law mailbox rules presumption of receipt to put the ball in the VA's court to prove that they did not receive what the law presumes that they did. If you have any questions, feel free to pop them in the comment section below this video, and I'll do my best to at least read most of these comments. I do see a lot on lot of different platforms, but I do my best to try to see them all. And if there's any that express a common concern, I will address that in a future post. Until the next time, y'all have a great day. Take care, stay safe, and stay healthy.